This is Chapter 11 lecture video, Developing Law of Search and Seizure, Chapter 11. Let's first look, so you should have already read the chapter, you have your PowerPoint open, and you have your textbook next to you. Let's start off on page 314, Myths and Facts. Myths about warrants, exclusionary rule, and the fruit of the poisonous tree. Myth: if the police wish to conduct a search, they must obtain a search warrant. Fact: there are numerous exceptions to the search warrant requirement. Myth: for a judge to issue a valid search warrant, there must be sworn testimony from at least one eyewitness to the crime. Fact: the U.S. Supreme Court allows judges to issue search warrants based on the totality of the circumstances. If all the facts in the affidavit for the warrant, taken as a whole, provide probable cause that the evidence of the crime is currently at a specific location, a judge can issue a warrant to search the premises. One type of evidence is not preferred above another kind as long as the evidence is credible. Again, probable cause is 51% certainty. Myth: when serving a search warrant, the police may seize things only that are specifically listed in the warrant. Fact: in addition to the items specified in the search warrant, the police have the right to seize anything that falls under the plain view doctrine. Myth: the exclusionary rule is no longer used in the United States. Fact: the exclusionary rule is still in use in the United States, but decisions of the U.S. Supreme Court have narrowed its application. Let's look at page 315 in the middle. There are three broad concepts to the Fourth Amendment. 1. The protection is provided for the person, home, and belongings. 2. Unreasonable searches and seizure are prohibited. And 3. Warrants must be based on probable cause and specifically describe the place to be searched and what is to be seized. And it's broken down even more in chapters 12 through 14. Slide 5, the Fourth Amendment, its history. Before the American Revolution, British searched homes and businesses wherever and whenever they wanted to. The Fourth Amendment bars the warrantless search and seizures. There are three broad concepts that I just mentioned on page 315. Slide 6, definitions of search. The examination of a person, house, or property by the police or their agents. Not every act of investigation is a search. Not every search is covered. Only reasonable searches impact admission of evidence. Page 316. Let's look at probable cause again at the top. A reasonable belief that a person has committed or is committing a crime, or that a place contains specific items connected with a crime. Under the Fourth Amendment, probable cause must be shown before an arrest warrant or search warrant is issued. And again, that's 51% certainty or greater. Standing, a legal term that refers to the right to ask the court to take legal action. Search. A search involves the act of looking for something that otherwise would not be seen. It invades someone's reasonable expectation of privacy. Finding something that was left out, that's plain view. That's not, could not see, is not a search. Next paragraph, if there is a search, it may not violate the Fourth Amendment. Only reasonable searches are prohibited. Only unreasonable searches are prohibited. Let's look at examples of actions that are searches. Police officer orders the suspect to empty his pockets and carefully examines each item that is produced. If the officer did this before arresting the suspect, it is unreasonable, unless they thought there was reasonable suspicion of a weapon, and then they could pat them down. If the officer arrested the suspect before ordering the pockets emptied, the officer's action would be a reasonable search. That's going to be talked about more in chapter 12. A police officer goes to a farm and finds a field of marijuana plants. If the officer searches close to the farmhouse, his actions are unreasonable. If the officer searches open fields that are not near a dwelling, the actions are reasonable. That's talked about more in chapter 13. Slide 7. Seizure is taking possession of a person or property. Seizure of a person is an arrest, but seizure of items requires an owner to have expectation of privacy and control. Page 13, at the bottom, police seize evidence when they take it in their possession. When a person is seized, it's an arrest, even when there's no search. If something was left out in plain view where the police could see it, officers still must have probable cause to seize it. If a police officer observes something inside a house by looking through a window, there's no right to enter the house to seize it without a search warrant. Top of page 318 of your textbook. Examples of actions that are seizures. Police stop a man carrying an object that appears to be a gun. They immediately seize the object. An arrest can be made as soon as it is determined that the man does not have a permit to carry the gun. When the suspect is booked into the city jail, officers remove all personal belongings in the suspect's possession. Officers go to a bank and obtain a copy of the suspect's checking account records. A court order is needed in order to make this a legal seizure. Probable cause, slide 7. Reasonable belief based on facts that a person committed a crime, and an arrest is made, or that a location contains evidence related to a crime, a search is made. Bottom of page 318, probable cause. The Fourth Amendment specifically refers to issuing warrants based on probable cause. In criminal cases, probable cause is required in 3 key situations. Probable cause that a crime was committed, probable cause that the suspect is the person who committed the crime, probable cause that the evidence is at a specific location. Top of page 319. Examples of probable cause to make an arrest. Police arrive at the scene and observe the suspect hitting another person with a baseball bat. A woman calls 911. When the police arrive at her house, they observe that the woman has red marks on her face, indicating she has been recently hit. The woman tells the officers that the suspect hit her with his open hand. Slide 8, probable cause. Necessary before an arrest or search warrant is issued. Probable cause may also be used to conduct some arrests and searches without warrants. Standing, a legal term that refers to the right to ask the court to take legal action. This term was replaced by reasonable expectation of privacy. Let's look at page 320. In the middle, or toward the end, examples of the right to have evidence suppressed. Sam was illegally stopped by the police and his car was searched. Mary, who is a suspect in a theft investigation, is spending the weekend with her brother Ned. Police enter Ned's apartment without a search warrant and find the items that Mary stole. Those are examples to have evidence suppressed. Slide 9, general information on warrants. Requirements for a warrant. Probable cause, oath or affirmation supporting information, describe an individual arrest or the item in place to search. Made to a neutral magistrate or judge. There's strong preference for warrants over warrantless searches. Page 321, warrant requirements. The Fourth Amendment specifically states no warrant shall be issued unless there's probable cause. Probable cause must be established under oath or affirmation, and the warrant must particularly describe the place to be searched and the person or things to be seized. The Fourth Amendment does not say that all searches must be made by authorized warrants. Below, next paragraph at the bottom, search warrants may be issued to search nearly any location, including residences, newsrooms, lawyers' offices. Bottom of that page, of page 321, the basic principle is that warrants are mandatory except when the fact fits one of the exceptions to the warrant requirement. This chapter deals with warrants, and the numerous exceptions to warrants are covered in chapter 12 and 13. Top of page 322, information needed to obtain a warrant. The warrant process mandates that a neutral judge or magistrate reviews the facts and decides if the police should be authorized to conduct a search or make an arrest. To do this, the judge must have the facts of the case. The Fourth Amendment requires that these facts be taken under oath or affirmation. That written document is called an affidavit. Okay. Slide 10, general information on warrants. Affidavit contains sufficient detail to know what is being searched for and where. It generally limits the search. It should not exceed contents of the warrant. Warrants without sufficient probable cause are invalid. Let's look at the middle of page 322 under search warrants. Facts are given in an affidavit are usually very detailed and must convince the judge that there is evidence at a specific location that the officers have a legal right to seize. Next paragraph. In addition to showing what is seized, the affidavit must give facts that show where the items to be seized are located. The items to be seized also must be listed in the warrant. The description of the location to be searched must be as exact as possible. Let's look at page 323, second paragraph. A problem unique to search warrants is the requirement that the information be fresh. If the facts are stale, they may not be a reliable indicator of where items to be seized are currently located. And look at the bottom of that paragraph. It is important for the police to have current information to avoid rejection of the affidavit due to staleness of the where things are located. Slide 11. Actually, I have to stop